Firstly, we should bear in mind that the definition of harassment in the employment legislation is very broad. It encompasses other types of conducts like bullying, assault, sexual harassment, and so on. The primary obligation of an employer when it receives a complaint of harassment is to initiate an investigation as soon as possible, and in any event within 15 days of having received the complaint. We should also bear in mind that the employer may be held itself liable for an act of harassment which has been perpetrated by one of its employees against another employee. In Mauritius, all employees are entitled to 15 days of paid sick leave annually. These sick leaves have to be paid sick leaves. On the other hand, nothing prevents the employer from giving more sick leaves or from allowing the employee who is sick from being absent from work but on an unpaid basis. Emails are usually the property of the employer. Emails are provided to the employees for them to use as part of their work. The use of emails and the monitoring of emails can be an important way in which employers are able to monitor the performance of their employees. Whilst it could be said that under the data protection laws in Mauritius, the monitoring of the email is essential to monitor the performance of a contract, we would still advise employers to insert in their employment contracts that they give to their employees a clause allowing them explicitly to monitor the emails for the purposes of ensuring compliance with employment contracts and with policies in place at the employer.
So, Mauritian law currently, I understand, does not cater for parental leave. From a South African perspective, there is parental leave that was introduced about 5 or 6 years ago. In addition, South Africa provides for adoption leave. So parental leave together with adoption leave is recognized in South African law, and that seems to be where the rest of the world is also moving to, and Mauritius appears to be moving, as I understand it, in that direction too. Remote working has obviously taken the world by storm, and laws are way behind in regulating remote working. So for employers and employees, it is absolutely fundamental that they put things in writing. The things that should be in writing, such as policies or contracts, are who is going to be able to work from home or remotely, because not all positions and functions can. Then the hours of work must be regulated. The safety laws that apply must be regulated. The monitoring, whether an employer is going to monitor whether an employee will be monitored remotely, must be regulated, as well as the tools that the employer will provide to the employee in order to get the work done remotely.